Hap May with Legal Play.
And I'm Chelsea El-Azzi, Hap's associate. Hap, today I want to discuss the different types of entities as far as like businesses and organizations, LLCs, corporations and partnerships, and basically what kind of corporate documents each of those entities needs to have and what type of formalities that they should be following so that they are,
And perhaps why they need them.
Yes. To stay compliant and do what you should be doing to make sure you're running it properly. I feel like I want to start with LLCs. I feel like LLCs are kind of
LLCs are probably the most common in this modern age for at least small businesses.
And I want to say they're pretty straightforward with what they need to be
and they're pretty straightforward. Problem is one of the reason attractions for an LLC is because it's less burdensome with regard to some of these document requirements, which means that some people do very little and don't do, even though there are only a limited number of requirements. I mean, a lot of people just don't do them.
Right, and I mean, you right. So that's what we're here to talk about. Is you still need to have some kind of corporate documentation in place. So for an LLC. With any of these entities, a partnership, a corporation, or an LLC, you're going to, file the necessary paperwork with the Secretary of State.
Right, with a caveat that if it's a general partnership, not a limited partnership, it does not require a filing with the state.
Oh, okay.
You can have a partnership agreement where everybody is a general partner, meaning they're liable for the debts of the partnership, without a public filing.
Okay. Well, that's good to know. Once you do file or not file, if the the case may be, then and your entity is accepted by the state, you do need to have other corporate documents.
Yes.
Existing for especially if you want to open a bank account, banks are going to want to see certain documents.
In particular, LLC is talking about that. LLCs can be a single member LLC.
Mm-hmm.
In fact, that's quite common in our practice and others. And it comes with the tax advantage of it could be treated as a disregarded entity if the proper election is made on a form 8332.
Or if you want to treat it as a corporation and have it taxed as a corporation, you can do that too.
You can do that, and you can also make an S election to treat it as an S election. So that's kind of the tax options for an LLC.
Mm-hmm. And LLCs, we've made a lot of LLCs to be general partners of certain limited partnerships. So there's a lot of advantages of just creating an LLC.
Right.
What you're going to need if it's an LLC is what some people call either a company agreement,
right,
or an operating agreement.
Which is basically in a corporate comparison similar to the bylaws. It is the governance document by which the LLC will be governed.
Yep.
And if they're and obviously in a single member LLC, it's a pretty simple thing because of the single member, 100% shareholder or owner of the LLC can pretty much change it whenever he wants to.
Right, but go ahead.
But one of the problems, and in theory, I guess you really wouldn't need one except for the fact that you want to do business and you're going to want to open a bank account, and the bank's going to say, okay, give me the governance document, give me your company agreement, and if you say, well, I'm a single member LLC, I don't answer that. So we don't know that. We, the bank, don't know that unless you give us the operating agreement that says you're the only member.
And the operating agreement is going to name a manager who can sign documents and open bank accounts, and I think some of the operating agreements even need to say that this manager has the authority to open bank accounts and sign checks. And
typically that's it. An LLC could have an agreement that is managed by its members too.
Right.
And again, when you go to a title company to sell something or open a bank account, neither the title company or the bank are able to tell whether it's a member managed or manager managed entity without looking at the governance documents.
And that you bring up a good point, because the members are the shareholders. The members are the ones with the interest in the company.
The owners.
The manager is just the one that can do stuff on behalf of as an agent. And manager doesn't necessarily have to have any ownership interest in the LLC.
It does not have to, no. Does not.
So sometimes you could just have somebody, managing that
In
has no rights.
in most small business, if the single member is a manager, or one of the owners, one or more of the owners could be, because it's usually small businesses.
Mm-hmm.
And there's not a lot of people to choose from, and the owners want control.
Right. So that's an LLC needs the operating or the company agreement. A partnership needs a partnership agreement.
Partnership agreement. If it's a limited partnership agreement, meaning limiting the liability of the owners, the limited partners, then there is a filing with the state. You need at least somebody or some entity to be the general partner. Mm-hmm. That's where you got into a minute ago. We talked about sometimes we form an LLC. It owns 1% of a limited partnership. It serves as general partner, so it is in control of the limited partnership.
And the manager of that LLC would be the one to sign off and act as general partner.
Right, whoever,
Mm-hmm.
right, or somebody appointed by
correct.
that LLC general partner
Correct.
would act on behalf of the limited partnership. And the limited partners usually have limited, ability to control, which is the idea, because they want to limit their liability to only the investment they've made, not to be responsible for the debts of the limited partnership.
Focusing on the corporate document, though, the actual, the organizational document, the partnership agreement would explain everybody's role.
The partnership would be the governance document.
Yeah, it would say this is the general partner and name the general partner and say the general partner has the power and responsibility to do all of this. These are the limited partners. The limited partners are limited in these ways and only have this. And then there would be some kind of addendum or schedule at the back which would show the partnership interests.
Right, and that's 10% or 20% or whatever it is.
Right.
Yes.
And so for a partnership, you're going to have a partnership agreement. And there are different ones depending on your type of partnership. Sometimes we have family limited partnerships, and the provisions are slightly different.
Slightly different. Generally speaking, a family limited partnership gives more control and discretion to the general partner. The idea being that if things like you don't have to make distributions. Things like the limited partner cannot, under really any circumstances, replace the general partner. And the idea being is, one, there's an estate planning advantage to that, because somebody dies, limited partner dies, even though his pro rata share of the assets may be $1 million. Because he lacks control and cannot force the general partner to liquidate or to make payments, they get a discount for federal tax purposes, and something like a 30% discount is fairly common. So that even though they have $1 million, it only gets scored on their Form 706, the estate tax return, as being about $700,000 in value. And if you have a taxable estate, or the decedent has a taxable estate, you want to get lower values, so the estate tax that has to be paid is less. It's one of the reasons we have family limited partners. The other is that if one of the limited partners has judgments against them, there is no requirement that a distribution be made to the limited partner. So I'm a limited partner, I've got this big judgment. For whatever reason, some big bad business deal I got into, or maybe I was in a car wreck or something like that, and my creditors come to me and say, what do you own? I own this limited partnership interest. They go to the general partner and says, just distribute money that should be going to HAP to the creditor instead, and the general partner says, I don't have to make a distribution. Mm-hmm. Here's the governance document. I'm not required to make a distribution.
You can tell he knows a lot about this.
Well, yeah, that's not big. Yeah, I've given the spiel before in my life. Yes.
Well, and I know a lot about these because in my time working with you, I have put together my fair share of operating agreements and partnership agreements, and now we're getting to it, bylaws for a corporation.
Right, and a corporation. First of all, there's articles of incorporation, saying we are incorporating, and that is a public document filed with the Secretary of State, if it's in Texas, or whatever the state process.
And that one's not too difficult. It doesn't involve much. You just need to have, the name and the address, who's going to be receiving all the mail for it. But you do need to have the initial directors. Right. And so that's where a partnership has partners. A corporation is going to have directors.
Well, corporation will have shareholders who are the owners.
Right.
The shareholders will elect at a meeting which is described in the bylaws who the directors are going to be, how many directors and who the directors are going to be. Then the directors get together and choose officers, president, vice president, secretary, treasurer, CEO, CFO, whatever other officers are called for.
Right.
And
for the purposes of meetings, there also need to be usually a chairman of the board.
There will be a chairman of the board or a chairman of the meeting of the board members, which doesn't necessarily have to be the same person.
No, and it's pretty much just whoever feels comfortable running the meeting. It doesn't have to be the president or the CEO.
It does not. It needs to be a board member, but
yeah.
And sometimes the president and CEO aren't board members. Sometimes they are. Sometimes they're not.
But usually the chairman is the one that says, "I call this meeting to order."
And yes,
meeting is adjourned.
That would be temporary chairman, and you can elect a chairman during the course of that meeting.
Correct. And
when you get into sort of contested board meetings, a lot of times board meetings, and the same would apply to a meeting of managers of the LLC or something like that. If you got some factions that are arguing with us over something, sometimes you can have a very contested board meeting, so who gets elected chairman is something that may not be that routine.
Right. But initially, in the bylaws, the very first document that gets put together, not the very first, but one of the first documents that gets put together for the corporation is going to be the bylaws,
right? Which
says, okay, here's the general purpose, and here's the, it names I think the directors, the ones I've put together, the initial directors are in the bylaws.
It can be done that way. And the shareholders vote to adopt the bylaws.
Correct.
And they've adopted the selection.
But it does say, what's possible, like what potential roles, what roles are definitely there in the beginning, and what potential roles there may be if the board decides, and what. If there are going to be officers, what roles those are.
Right. And I mean, what it takes to amend the bylaws.
Yes. If it needs unanimous consent of the shareholders or board.
Or just 2/3, which is fairly common, or just a regular majority of 50 plus one vote. Get you there. So that's the determination.
Which it's interesting because some of the things we've come up with is constituting a quorum being like what it takes to make the meeting official, and that the board members can actually discuss what it is. And quorum is kind of like, it's usually a majority of the directors that have voting ability. Right. The quorum is actually going to be listed in the bylaws. It's going to say what
quorum requirement. I guess
what constitutes a quorum, and if it's not there, then it defaults to state statute.
Right.
But the shareholders can decide what they want a quorum to be. And if it's a majority of the directors, and then what it takes to get a vote passed is also the majority. In this case, it would probably be good to make more than an even number, to avoid an even number.
Even number of directors, so you can avoid
deadlocks,
or what that is.
Yeah.
That
certainly
is the logic that a lot of people.
We're dealing with that currently with a client who keeps coming up against a deadlock, and that brings me again to just the different documents, the different corporate documents you need to have with a board in a corporation, or I guess any really board or meeting. There definitely need to be meeting minutes.
Well, that's at the meeting. First of all, you need to notice the meeting,
right?
And the bylaws will prescribe what kind of notice. Sometimes 10 days, sometimes 3 days,
right?
And
if you can just send a text message or an email, if that's enough of a notice, the bylaws would say that.
Yeah, that was not in the bylaws I drafted 35 years ago when I first started doing this.
No.
Yeah.
No, but like you could call them up and say, hey, how's Tuesday morning at 9 o'clock work? Yeah, that's fine for me. That's technically notice. If it's in the bylaws, that's okay. But yes, once you do have meetings, you'll need to record minutes. Well, what if we can't all get together? What if we know we all agree, or are going to, and we just want to read, on it.
Or enough of us agree, either at shareholder level or the board level.
Right.
There is a document where the board members or the shareholders can consent to action in lieu of a meeting.
Correct.
And that procedure has to be set out in the bylaws, or I believe you can't do it. I'm not sure that there is a provision in the state statutes that
I don't know about in the state statutes.
Allow to do that if it's not in
the bylaws I've drafted allow for that.
Right.
And a lot of our clients actually prefer that because sometimes it's hard to get everybody together. And if you just want to email out and have some phone calls, out of the meeting, and everybody kind of understands what's going to be coming up to them for a vote, then you can, e-sign, electronic, PDF sign some things, and it's going to be a document, a consent in lieu of meeting.
Right. Where,
here are the resolutions.
Right. And then the either shareholders or board members are taking action without the necessity of a meeting. Mm-hmm. And if you have 5 board directors and it doesn't require 2/3 vote, 3 of the board members can sign a action or consent to action in lieu of a meeting. Same with shareholders. Shareholders can sign. If it requires a 50% vote to say to elect a new president, a new board member because one of the board members has resigned or died or something like that. If you have, and it takes 51% to elect a new board member, you could have, 51% of the sign a consent in lieu of action and make it president. Sometimes that's easier to do. If you're going to have Zoom meetings, it's probably best to put that option in the bylaws that is permitted. I'm not exactly sure what the law said. If you have a Zoom meeting of the board without notice or without having that specific provision, whether that's valid or not, probably is, but it's better off to have it in the bylaws in the process to allow for just an easier process.
So that brings me to to my question of why does this all matter? I mean, you said yourself that there are a lot of single member entities or even like a husband and wife duo, and they're like, why do we need to hold meetings? Why do we even need to record meetings? Can't I just do these things, take these actions without actually like having it on paper that we voted?
And disputes arise between shareholders and directors when companies start getting sued, when they start having liabilities or start having problems, or things become good. I mean, they become so good they're have merger and acquisition, people trying to gobble them up or buy their assets or something like that. If everybody remembers when Elon Musk took over Twitter, he made what was $40 billion offer or something like that, and the board of Twitter, he was in a dispute with the board of Twitter about some policies and whether who they can exclude. Evidently, President Trump being one of them, and there was a debate amongst the board. Well, should we sell? And then when they saw the $40 billion offer, the majority of them said, "Yeah, I think we should sell this." And something like that. But there was issues with the board, and I presume there may have been some board members that said, no, we shouldn't do that. And so having these documents, following the procedure, is an important thing.
Yeah, and for the IRS purposes too, there may be times when.
Well, for IRS purposes, they come in. There was this transaction authorized, with the issuance of new stock.
Or just money being moved around from entity to entity.
Right, and particularly if you got related parties, you got the board of a subsidiary and the parent, and the transaction between the parent and the subsidiary.
You can't just wire yourself money and say
or a related company. And there's this thing called the corporate opportunity doctrine, which means that if a corporation has an opportunity and one of the directors or officers diverts it to another company that they may have an interest in or something like that, then there's a suit against the director. There's all kinds of liability and suits in connection with this, and if proper procedure is not followed, that makes whomever is involved in it more vulnerable to a lawsuit with regard to that. So if you want to take some action that may create some controversy, first thing is to make sure that you procedurally do it correctly under the terms of the bylaws or the membership agreement, and to the extent that your action, the approval of your action is absent, and how you do that under state statute. I mean, you would look to state statute if the bylaws or operating agreement don't give you the answer.
Mm-hmm. And then any transactions you take, if it needs to be, documented.
Document it. Document. Because
yeah.
when you get sued 3 years later, you'll understand. This is why did you sell this particular asset to somebody else right before it jumped twice, it doubled in value. You can say, well, I got approval, and they say, how'd you get approval? Well, we got on the phone. We got on the phone call, or we met in the clubhouse after we played golf, and we all got said, yeah, let's do that.
And here's the meeting minutes that says all of that and resolved.
And if you have the meeting minutes, that's good. I mean, if you don't have the meeting minutes, then there's I'm sure that some of your other shareholders or board members may not remember approving that. If it did kind of divert an asset that jumped in value in the process, or you bought an asset that tanked in value right after you bought it. So those are all things that you want to be in a position to say, I got approval from shareholders, I got approval from board members, I got approval from my partners as required by the partnership agreement, the bylaws, or other documents.
Yeah. All this to say, if you're thinking about, creating an entity for some reason and you don't know if it needs to be an LLC, a partnership, a corporation, we can help you decide.
Yes.
You don't know what documents need to be in place to create this entity and bring it into this existence. We can put those together for you.
Yes.
You want to make sure you're following all the formalities and making sure that all the documents need to be in order to go along with that entity creation and any transactions or actions that that entity may be taking. We can help you with that.
Yes.
So I think that about wraps up this topic for the day.
Well, thank you. And this is Hap May with a Legal Play.
Thanks, Hap.
Recording stopped.
Okay, that was